Welcome to Case Chronicles. Today we're going to talk about siblings, which is usually the category of people that are fighting in court. So I have two siblings I represent one of the siblings. Let's call my client Sheila. And Sheila was the 50% beneficiary of Will A. And Sheila's evil sister, Betty, I can't pick that name because that's my friend's mom's name. Sorry, Betty, it's Betty. So Betty has a competing will that was executed later in time. So the reason a will is called a last will and testament is because the last one is the one that should be the valid one, is the one that the court admits, the one that we, have distributed through. So Sheila and Betty have, I always break my pens, that's what it is. Betty's will is later in time. I think it was executed like maybe 6 months after Sheila's will. And Sheila is now fighting Betty because she feels that Betty procured this will by unduly influencing their mom to execute a will in favor of Betty, because Betty's will disinherits Sheila 100%. And I think they both had issues with their mom and strange relationships, and one of them lives out of state, one of them lives down here, and she was constantly going back and forth between them and constantly changing her wills. So really the fight is, was she influenced to change her will? Did she have capacity to change her will? Which will is the winning will? Wish I could tell you what the end result of this particular case is, but we are not there yet. If you want to avoid this for your family, don't have a will, or don't just have a will. I know that sounds weird coming from an estate planning attorney, but a will is not the best planning tool. It is a planning tool and it could be useful, but you want to make sure that you want to leave as much of the fighting between siblings outside of court. Make sure you have a trust, and obviously properly drafted with an attorney so that your kids aren't duking it out in court. Get ahead before you're dead.